Hi friends, in this video we are going to deal with the important and latest Supreme Court judgments pronounced now in the area of criminal procedure, educational and property laws. To know more about them, please watch the video fully. In the important judgment titled Sunil Kumar versus State of Bihar and another, and pronounced on 25th January 2022, the Supreme Court has held that the gravity and nature of the offence alleged against the accused are relevant considerations while considering his bail application. The facts of the case would be that the appellant, the younger brother of the deceased, lodged FIR against all the accused for the offence under sections 147, 148, 149, 341, 323, 324, 427, 504, 506, 307 and 302 of IPC and section 27 of the Arms Act for having assaulted them and killed his elder brother, who succumbed to the bullet injury. All the accused persons were arrested, including respondent number 2, the accused. The bail application filed by the respondent number 2 came to be rejected by the Sessions Court by giving cogent reasons and by observing that the respondent number 2 and other accused persons named in the FIR formed an unlawful assembly and thereafter killed the deceased. Thereafter, the respondent number 2 approached the High Court by way of application under section 439 of CRPC. The High Court released the respondent number 2 on bail. Feeling aggrieved and dissatisfied with the impugned judgment and order passed by the High Court, the original informant, the younger brother of the deceased, who himself is an injured eyewitness, has preferred the present appeal with allegation that the High Court committed a grave error in releasing the respondent number 2 on bail in a case where one person is killed and no reasons have been assigned by the High Court. The Supreme Court has held that while granting bail, the relevant considerations are nature of seriousness of the offence, character of the evidence and circumstances which are peculiar to the accused, and likelihood of the accused fleeing from justice, the impact that his release may make on the prosecution witnesses, its impact on the society, and the likelihood of his tampering. From the impugned judgment order passed by the High Court, it can be seen that no reasons whatsoever have been assigned by the High Court while releasing the respondent number 2 on bail. Neither the High Court has considered the gravity, nature and seriousness of the offences alleged against the accused. Even otherwise, the High Court has erred in not considering the material relevant to the determination of whether the accused was to be enlodged on bail. The High Court has not at all adverted to the relevant considerations for grant of bail. Even the High Court has also not at all considered the criminal antecedents of the respondent number 2. Though it was pointed out on behalf of the informant that the accused is involved in 2 cases and that the appellant was restrained from proceeding further in earlier cases pending against the accused, the High Court has simply brushed aside the same and has not considered the same at all. Applying the law laid down by this court to the facts of the case at hand, and more particularly considering the fact that respondent number 2 is the history sheeter and is having a criminal antecedent and is involved in the double murder of having killed the father and brother of the informant, and the trial of these cases is at the crucial stage of recording evidence and there are allegations of pressurizing the informant and the witnesses, the impugned judgment and order passed by the High Court releasing the respondent number 2 on bail is absolutely unsustainable and the same cannot stand. At last, the High Court has not at all considered the gravity, nature and seriousness of the offences alleged. Therefore, the impugned judgment and order passed by the High Court is hereby quashed and set aside. Coming to the next important judgment titled State of Punjab versus Anshika, Goel and others, and pronounced on 25th January 2022. In this judgment, the Supreme Court holds that no mandamus can be issued to the state to provide for reservation. The facts of the case would be that state of Punjab enacted the Punjab Private Health Sciences Educational Institutions Regulation of Admission, Fixation of Fee and Making of Reservation Act 2006 for the regulation of admission, fixation of fee and making of reservation in private health sciences educational institutions in the state of Punjab. The state framed its sports policy in the year 2018, which provided that 3% reservation in admissions will be provided for graded sports persons. By order, a conscious decision was taken by the government to provide 1% reservation for sports persons. Though 1% seats were reserved for sports persons and the children, grandchildren of terrorist affected persons, so far as the state quota seats in government institutions are concerned, similar reservation was not provided for admission to private institutes, even with respect to the government quota seats in the private institutes. For a bunch of writ petitions filed before it, the High Court of Punjab and Haryana issued directions directing the state to issue a notification providing for 1% reservation or quota for children or grandchildren of terrorist affected persons, Sikh rights affected persons in all private, unaided, non-minority, medical or dental institutions in the state of Punjab. The court also directed that the said reservation or quota shall apply to management quota seats as well. It further directed that the fresh notification shall also provide for a sports quota of 3% in government medical or dental colleges. The state has preferred the present appeals. The questions posed for the consideration are whether the High Court was right in issuing directions directing the state to issue a fresh notification providing for 1% reservation or quota for children or grandchildren of terrorist affected persons, Sikh right affected persons in all private, unaided, non-minority, medical or dental institutions in the state of Punjab, including the management quota seats, and whether the state government's action taking a policy decision to prescribe a particular percentage of reservation or quota for a particular category of persons can be interfered with by issuance of a writ of mandamus directing the state government to provide for a particular percentage of reservation for a particular category of persons other than what has been provided in the policy decision taken by the state government. The Supreme Court has held that the first issue, whether the High Court was right in issuing directions directing the state to issue a fresh notification providing for 1% reservation or quota for children or grandchildren of terrorist affected persons, Sikh right affected persons in all private, unaided, non-minority, medical or dental institutions in the state of Punjab, including the management quota seats, has become academic, and therefore the present appeals are disposed of, keeping the questions of law open. As the admissions are given for the academic year 2019-20 pursuant to the interim order passed by this court, it is directed that the said admissions shall not be disturbed or affected. However, it is observed that this court has not entered into and or consider any other dispute, including whether the admissions are made on the basis of merit or not. If anybody has any individual grievance, in that case, it will be open for the aggrieved person to take recourse to law. Now, so far as the directions issued by the High Court directing the state to provide for 3% reservation or quota for sports person instead of 1% provided by the state is concerned, it appears from the impugned judgment and order passed by the High Court that it has issued the said direction considering the sports policy 2018. It is true that as per clause 8.11.5, 3% reservation for sports persons has been provided. However, it is to be noted that clause 10 permits or allows any other department to have specific policy providing for reservation for sports persons other than 3%. As observed herein above, thereafter the state government has issued an order dated 25th 7 2019 providing for 1% reservation or quota for sports persons. The said order has been issued and 1% reservation or quota for sports person is provided after taking into consideration the sports policy 2018. Therefore, a conscious policy decision has been taken by the state government to provide for only 1% reservation quota for sports persons. Applying the law laid down by this court to the facts of the case on hand, it is clear that the High Court has committed a grave error in issuing a writ of mandamus and directing the state government to provide for 3% reservation or quota for sports person instead of 1% as provided by the state government. A conscious policy decision was taken by the state government to provide for 1% reservation or quota for sports persons. A specific order dated 25th 7 2019 was also issued by the state government. Therefore, the High Court has exceeded its jurisdiction while issuing a writ of mandamus directing the state to provide a particular percentage of reservation for sports persons, namely in the present case 3% reservation instead of 1% provided by the state government, while exercising powers under Article 226 of the Constitution of India. Therefore, the impugned common judgment and order passed by the High Court insofar as directing the state to provide for 3% reservation for sports persons and or provide for a sports quota of 3% in the government, medical or dental colleges is unsustainable and the same deserves to be quashed and set aside. Now we are going to deal with the important judgment titled KESHAV and others versus GIAN and another and pronounced on 24th January 2022. In this judgment, the Supreme Court has held that voluntariness and animus are necessary for the execution of a valid gift deed. The facts of the case would be that GIAN and Danbir instituted civil suit for declaration that late Harda gifted the land to them during her lifetime with a registered gift deed. The suit preferred by the plaintiffs was dismissed by the trial court, observing that though the gift deed was a registered document, the document was of a decrepit origin. The civil appeal preferred by the plaintiffs before the district judge was also dismissed, with the first appellate court evaluating the evidence on record to affirm that the execution of the gift deed by Hardai in favor of plaintiffs was a delusion. On second appeal, the High Court of Himachal Pradesh held that the gift deed satisfies the legal mandates of Section 122 and 123 of the Transfer of Property Act 1882, and being a registered document, it enjoys presumption of truth. Therefore, the present appeal has been filed. The Supreme Court has held that the concurrent findings of the lower courts delve into the context and factual aspects surrounding the primary evidence of this gift deed to conclude that the plaintiff's case lacks base for a bona fide claim for decree of declaration. Considering that the very origin of the gift deed was disputed by the executant during her lifetime, the lower courts were right in weighing the evidence of the gift deed on the touchstone of its validity first, rather than its form and content. The fact in issue in the present case is the voluntariness and animus necessary for the execution of a valid deed, which is to be examined on the basis of evidence led by the parties who could depose for the truth of this fact in issue. Decision and determination of the fact in issue is by examination of the oral evidence of those persons who can vouchsafe for the truth of the facts in issue. The impugned judgment in the second appeal by the High Court unfortunately chose to ignore and not deal with the fact in issue in the background of the case, but was completely influenced by the evidence led to support execution registration of the document, and not whether execution was voluntary and in exercise of unfettered will to effect gratuitous transfer of land in favor of the plaintiffs. When a person obtains any benefit from another, the court would call upon the person who wishes to maintain the right to gift to discharge the burden of proving that he exerted no influence for the purpose of obtaining the document. The courts can apply this principle to old, illiterate, ailing, or infirm persons who may be unable to comprehend the nature of a document or contents thereof. The concurrent findings of the facts arrived at in the present case were based upon a holistic examination of the entire evidence relating to execution and validity of the gift deed. The lower courts did not adopt a legalistic approach but took into account not one but several factual facets to accept the version given by the KESHAV that the gift deed was not a valid document. These concurrent findings are not perverse but rather good findings based upon cogent and relevant material and evidence on record. These findings of the facts can be interfered in the second appeal only if they are perverse or some gross illegalities have been committed in arriving at such findings. To reverse the findings is not only to assess errors but also deal with the reasons given by the court below and record findings and grounds for upsetting the conclusion. The findings were recorded after in-depth consideration of the factual matrix, including the statement of Hardai, an illiterate and aged woman who during her lifetime in 1989 had staunchly refuted having executed any gift deed transferring the property to the plaintiffs. Hardai was residing with KESHAV, who was looking after her and providing for all her needs. Further, the plaintiffs did not take any steps to get the mutation of the land records for about 4 years from 1st January 1986 till 1989. The rejection by the Revenue Authority in 1989 remained unchallenged till Hardai died in 1991. The views and findings recorded by the lower courts are well reasoned and have taken into account several factors that repel and contradict the claim of a valid execution of the gift deed by Hardai favoring the plaintiffs. Therefore, the impugned judgment is set aside and the decision and decree passed by the trial court and affirmed by the first appellate court are upheld.